to bring House Bill 2629 up to take a look at what we're going to do with that bill on final action. And Reviser, would you brief us on it briefly, please?
Thank you, Mr. Chairman. Committee House Bill 2629 would remove mandatory fines and jail time in KSA 8-287 and 8-262 for habitual violators who are convicted of driving on a suspended, canceled, or revoked license 3 or more times. The effect would be to continue to classify these violations as Class A non-person misdemeanors that carries up to a year in jail and not more than $2,500 in fines. And I'm happy to answer any questions.
Representative Hoheisel.
Thank you, Mr. Chair. Thank you, Mr. Reviser, for that. Just to clarify one more time, because last week there were a couple comments made about individuals do the crime, basically they should do the time. If this were to become law, they can still be sentenced up to a year in prison, correct?
That is correct, for being a Class A misdemeanor.
So this basically just gives a judge discretion, and that is it.
That would be a fair description, I think.
Thank you. Thank you, Mr. Chair.
Representative Hilgerson.
I think the problem is that it is being interpreted by some cities that is not an option, it is a mandatory. And with the amendment, with the bill, and with the subsequent amendment that you'll see, this gives that, it takes away the mandatory requirement for jail, but it still allows judge the discretion. Does that make sense?
Yep.
Representative Hoheisel.
Yeah, that's the point I was making, is that I think some folks, and I heard it from a few folks back home, think that we're removing jail time from habitually driving on a suspended driver's license. We're not removing jail time. We're removing the required jail time. You can still be sentenced up to a year in jail if this becomes law. That all we're doing is removing the mandatory minimum to allow judges discretion. If they want to do 45 days in jail, if they want to do 90 days in jail, they want to do 6 months in jail. This just removes and gives them that discretion.
Are there any further questions for the Reviser? Representative Ballard.
Thank you, Mr. Chairman. I think in light of what we just heard, though, I wonder if, I don't know if there's such an amendment, but it says HB 2629 would remove mandatory jail time for habitual violator convicted of driving while the driver's license is canceled, suspended, or revoked. And maybe, do we have to add after this, and it's at a judge's discretion?
Reviser Wagner.
Thank you, Mr. Chairman. It's up to the will of the committee, but a Class A non-person misdemeanor is defined in statute. Class A, the sentence for which shall be a definite term of confinement in county jail, which shall be fixed by the court, it shall not exceed 1 year. So that would be found elsewhere.
Okay, I'll stop at that point, Mr. Chair. Thank you.
Okay. Representative Hoheisel.
Thank you, Chair. I was just going to add on to that. By removing the mandatory minimum, it is basically giving the judge discretion up to a year in prison. So by just removing the mandatory minimum, does accomplish giving the judge discretion.
Representative Ballard.
The only reason I asked that is because you said you indicated you had people in your community that didn't understand it. So maybe sometimes we have to spell it out to make sure that when they're reading it, they don't just see that interpretation, but they see the rest would indicate, because they don't know the law or how it reads.
Yeah, Mr. Chair, I would think the issue was they were just reading or watching a news report and not necessarily reading the bill and just assuming from the news report of what we were doing.
Representative Helgerson.
Perhaps if it would be all right with the committee, there is an amendment that Ed drafted specifically to take care of this, so that his objection and the objection that the Highway Patrol had would be taken care of and put back to the original intent of the bill. And if it would be agreeable with the chairman, perhaps the reviser could hand out the amendment so that you could see that and see how it takes care of it.
Why don't you go ahead and make it a motion on the bill first?
I move the adoption of the bill as amended, as hopefully it'll be amended. No, just,
Then we'll do the amendment. Is there a second on bill? It's been seconded by Representative Ballard. Now, you have an amendment.
I have an amendment, and if the reviser would pass it out, I'd appreciate it.
Who would second the amendment? Representative Francis seconds. Why don't you go ahead? You're going to have the reviser. Okay. Reviser, would you explain the amendment, please?
Thank you, Mr. Chair. So, committee, if you'll see, the amendment would strike sections 1 and 2, which removes 8-262 and 8-287, which are where certain parts of the mandatory jail time were found for habitual violators. If you'll remember, the term habitual violators defined broadly in KSA 8-285 as any one of these 8 offenses, 3 or more times, being convicted of those. What the amendment does is, as I said, remove those sections and then add in KSA 8-285, which defines habitual violator. And if you'll find in subsection A1, cap C, that's where the language is being added to state that habitual violator is convicted of 3 or more times driving while the privilege to operate a motor vehicle on the public highways of the state has been canceled, suspended, or revoked, as prohibited by KSA 8-262. But there's an exception that's created for when such person's privilege to operate a motor vehicle or obtain a driver's license was canceled, suspended, or revoked solely for failure to comply with a traffic citation pursuant to KSA 8-2110. KSA 8-2110 is the failure to comply with the traffic citation statute. Basically says if anyone fails to appear before the district court in response to a traffic citation and pay any fine and pay in full any fine and court costs, if a person fails to do that, then they are guilty of failure to comply with the traffic citation, can have their driver's license suspended by the Division of Vehicles. So that's what the amendment attempts to do, is capture those specific suspensions and cancellations under 8-2110. And so the effect being those people would no longer be defined as habitual violators, and then the rest of the habitual violator statutes, including 8-287, and then where that reference is found in 8-262, that would require mandatory jail time. Those would not apply, since those individuals are taken out of the definition of habitual violator. And I'd be happy to answer any questions.
Representative Hoheisel.
Thank you, Mr. Chair. I do have a question for the reviser and then a question for the maker of the motion. I'm looking at the original 2629, page 19. I know I asked this question the other day, except as otherwise provided by subsection. Every person convicted under this section shall be sentenced to at least 5 days imprisonment and fine at least $100. And upon a second conviction, shall not be eligible for parole until conviction or completion of the 5 days imprisonment. Does this amendment touch any of that language?
No, it does not. It just pertains to mandatory jail time for certain habitual violators.
So if this amendment were adopted, we would remove the mandatory minimum for habitual, which is 3 times or more, but we would leave the mandatory minimum of 5 days imprisonment, 5 days imprisonment among the first or second violation of the Suspended Driver's License Act. So basically, with a judge's discretion, they could be sentenced to 5 days in jail for the second conviction, but on their third conviction, because we're giving the judge discretion, they could be sentenced to no jail time. Would that be accurate? I guess.
Yes,
Okay.
that is accurate.
All right. For my question for Representative Helgerson is: was there any discussion about maybe changing that as well?
No, we pretty much did exactly what the Police Chiefs Association suggested.
And please don't take any of my comments as I'm against it, because I'm in favor of this amendment and the underlying bill. I just want to make sure, because it seems a little uneven to me if we're saying, hey, on second conviction, you have a mandatory minimum of 5 days imprisonment, but on the third conviction, you may not get anything. So it just seems a little unbalanced to me, but that's something that we could look at further on down the road. Thank you, Mr. Chair.
Representative Helgerson.
There's also one other little amendment that was recommended by the department, and that was the date of implementation is now January 1st, 23, so that the department has time to put it into effect.
Representative Proctor.
Thank you, Mr. Chair, for the revisor. I thought I understood this amendment until the previous conversation. So what this amendment does is remove repeatedly driving on a suspended license because you didn't pay your fines, or which was suspended because you didn't pay your fines. It just removes it from habitual offender statute. So it's the 5 days and the year don't apply to it anymore. Is that correct?
I'm sorry, could you read
Okay,
that
so
last part?
so what I understood you to say is that this amendment removes driving on a suspended license for a third time from the definition of habitual violator if the suspension was because of non-payment of fines.
Yes, that is correct.
Okay, but doing it twice, you're still under the habitual offender statute?
No, I think what that is in reference to is in KSA 8-262, which is driving while license is canceled, suspended, or revoked. If you're convicted under that section, then you're sentenced to at least 5 days and fined at least $100. So it's a different punishment found at a different statute.
Okay. And that's regardless of why your license was suspended?
That is correct.
Okay, thank you, Mr. Chair.
Are there further questions to the revisor? Representative Hauser.
Thank you, Mr. Chair. This is more like a 3 strikes and you're out kind of thing, isn't it? You're going to get 3 chances here. With section 1 says 3 times or more, blah, blah, blah. So you're going to get three strikes and then you're going to get the jail time. Is that what this is saying?
Well, that's what the habitual violator statute says. And what the amendment would do is just remove some individuals who would qualify under that statute from that definition. But the remaining habitual violator statute is remaining unchanged.
Thank you, Mr. Chair.
Representative Helgerson.
If I might, last year we gave people the opportunity of going back in their records and paying fines, doing what they could to bring their records up to date. For this little quirk in the law, it required that even though that the judges, the prosecution, the defense, everyone agrees that this is the crime and this is what they are supposed to pay to get out of it, that even though they've done all those things, there may have been an issue 10 years ago or 20 years ago that they have to go back to jail. What I'm trying to do with this amendment and this bill is to say, we've already changed the law to allow people to move ahead with getting back their license. And if they've already fulfilled those terms and those requirements, then we don't want to throw them back in jail because they're doing everything they're supposed to do. And it allows the judge the opportunity of saying, that's correct.
Representative Delperdang.
Thank you, Chair. To the reviser, if I may, we've heard several comment about previous offenses 5, 10, 15 years ago coming back to bite you. On traffic offenses or infractions, is there not a statute of limits from a time perspective?
Advisor Wagner.
There is a certain look back period for, and I guess just pertaining to this amendment, habitual violator can be convictions within the immediately preceding 5 years. There are other certain look back periods provided, and those would just depend on the statute or offense.
Further questions for the reviser? Representative Helgerson, do you have anything you would like to add?
No.
Do you care to restate your
I have one
second?
question for the reviser. Since we've amended it, does it need to be a substitute?
It doesn't need to be. That's up to the committee.
Then I'll move the amendment.
Okay. Second, it was seconded by Representative Francis. You, right? Okay. You've heard the motion to amend. All those in favor signify by saying aye.
Aye.
Opposed, no. The ayes appear to have it. The ayes do have it. So we're back on the bill as amended. Representative Helgerson.
I move the adoption of the bill as amended.
You've heard, and it was seconded by Representative Hoheisel. You've heard the motion by question. I'm sorry, Representative Proctor.
Thank you, Mr. Chair. This is not so much a question as it is a pre-explanation of vote here. I'm not going to vote for this bill. I'd like to explain why I don't like it. If there were not the availability of a restricted license, if there were not the availability of a payment plan, I would say this was sorely needed. But because those things exist, you know, we heard the explanation. Well, some people, ironically, we heard it from a lawyer who said, my clients don't know that they have a opportunity for a restricted license. My clients don't know that they have the opportunity for a payment plan. Well, first of all, you're their lawyer. Why didn't you tell them? But second of all, this is a third offense. I would think on the first offense or the second offense, somebody would have told them, hey, why don't you go get a restricted license? And so if those mechanisms did not exist, I'd be in support of this bill. But because those mechanisms do exist, I am not in support of this bill. Thank you, Mr. Chair.
Representative Weigel.
Thank you, Mr. Chairman. Representative Helgerson, did you say that the KHB had signed off on this?
No, KHB has not signed off. I don't know if they've
Oh, they
seen
have
it.
not signed off.
They haven't seen the amendment. Ed worked up the amendment.
Thank you.
Further questions? Seeing none, you may close.
I'll close.
For the motion by Representative Helgerson to vote House Bill 2629 favorably as amended. All those in favor signify by saying aye.
Aye.
Opposed, no. No. Noes appear to have it. Division's been called for. All those in favor, raise your hand. I get 7. All opposed? Seven to 7. I will break the tie and I will vote yes and leave it to the, if it comes above the line, to the will of the body. Motion carries. Committee, that takes care of our business for the day. With that, we are adjourned.